Before we divulge into section 302 of Indian Penal Code, I would like to explain briefly section 299 as the former is an extended version of the latter. Section 299 defines the provision of murder, which is an act caused by a person to kill another person or to cause such bodily injury which in turn causes the death of a person or voluntarily commits an act which causes death. 4 elements होते हैं murder के. First one being offender, the person who commits the crime. Second one being mens rea, जिसका मतलब होता है guilty mind. Third one being actus reus, which means guilty act. And the fourth one being victim, which means the person on whom the crime is being committed on, who is deceased in this case. एक illustration देख के समझाती हूँ. A shoots B with the intention of killing him. As a result, B dies. The murder is committed by A. Now coming over to section 302 of Indian Penal Code, which defines the punishment for murder. According to this code, whoever commits crime shall either be punished with capital punishment, which is death penalty, or life imprisonment. और उसके साथ साथ फाइन के लिए भी लायबल होगा. डेथ पेनल्टी यूजुअली रेयरेस्ट ऑफ रेयर केसेस में दी जाती है, जिसका प्रिंसिपल वाज गिवन इन द केस रेयरली सिंह वर्सेस स्टेट ऑफ पंजाब, विच इज़ अ केस ऑफ 1980. द फ्रेज रेयरेस्ट ऑफ रेयर इज येट टू बी डिफाइंड विद रिस्पेक्ट टू द कंसर्न फॉर ह्यूमन लाइफ. द प्रिंसिपल ऑफ प्रोपोर्शनैलिटी ऑफ क्राइम टू of punishment to crime victim and offender is the foremost concern of the courts. Now coming over to life imprisonment of the courts, so there are 3 types of imprisonment granted. First one being solitary, which means a person is left alone in a compartment where there is barely any light or wind, so there is no human interaction whatsoever. Second one and third one being simple imprisonment and rigorous imprisonment. Same type of imprisonment, but the only difference is in rigorous imprisonment there is hard labor, whereas in simple imprisonment there is not so much hard labor. Now coming over to the fine part, so a person is charged with murder may also be liable to pay fine along with punishment as directed by the court. The quantum of fine is paid by the convict will depend on the discretion of the court. The court may consider in the manner in which the murder is committed and after due diligence shall pay the exact amount of fine by the accused to be paid by the accused. Now comes the case of minor sentence of murder. So basically, whoever doesn't know, anyone who is below the age of 18 is called a minor. Justice Lokur, who is the current chairman of the Supreme Court Juvenile Committee, stated that everyone held that death penalty cannot be awarded to juvenile convicts in every case related to heinous crimes like rape and murder. He said that every person who is about 17 years of age or close to 18 years cannot be given life sentence because just because they have committed a heinous crime. Proper inference must be obtained after going through all the evidence which pertains to the case. According to Juvenile Justice Act 2000, the death penalty cannot be awarded to the person below the age of 18 of the offence. The maximum punishment they can get is 3 years, and that too in the juvenile area. The Juvenile Justice Act 2015 replaced the act of this provision of 2000. The act which was amended can punish persons between the age of 16 and 18 years of age for committing a heinous crime such as rape or murder. The main reason was for passing this bill was the rape case, Delhi rape case, in which a 17-year-old boy had committed a crime and was only given the maximum punishment, which is 3 years imprisonment. This raised a lot of controversies and mandated the age of juveniles who have committed heinous crimes should be amended. Now, this Delhi rape case, which has many names, like Nirbhaya gang rape case, the original legal name is Mukesh and another versus State of NCT Delhi. The facts are, a young girl, around 23-22-year-old girl, was brutally gang raped in 2012. The court awarded the death penalty to 4 accused 8 years after the incident took place. Hence, this case became a classic example of the phrase justice delayed is justice denied, and brought a change in the provision of the death penalty under section 302, as the death penalty is now given in the cases where the offense of rape leads to the death of victim. Since 2008, 8 people have been sentenced to death and hanged. The recent ones are the four convicts from the Nirbhaya case. Since the Nirbhaya verdict, around 50% of death penalties is related to sexual offences. Hence, despite strong efforts from UN and other international institutions in abolishing punishment of death penalty across the globe, the recent trend in India shows that imposition of death penalty is still very much valid. It is one of the 56 countries to continue the practice of death sentence, while in 142 countries this practice have been abolished.